Welcome back inside Uplift Property Management. I'm Marley Davis, the Director of Operations, and today I want to talk about 4 legal pitfalls that cost San Diego landlords tons of money. The first type of legal risk I want to talk about has to do with eviction laws. So back in 2019, California passed the Tenant Protection Act, which was Assembly Bill 1482. And this outlines specifically what types of terminations of tenancies would fall under at fault versus no fault. And this is extremely important for San Diego landlords, any landlord in California, to know. The next thing I want to talk about is specifically the San Diego requirements, meaning that if this is a no fault termination of tenancy, there is now a relocation assistance requirement, which is minimum going to be 2 months, could be 3 months, depending on the specifics of the tenancy or the specifics of why you are ending the tenancy. And these details are really important for all landlords to review before they try to evict or terminate any tenancies in San Diego. The other thing that's really important to know is that your notices must be exact. I unfortunately have had to sit through many eviction court dates where I was sitting there in the same room as another landlord whose entire unlawful detainer case was thrown out because of language being incorrect in a notice. So not only is wording extremely important, but the way that you serve notice, the way that you are documenting that notice, and then the way that you are submitting that to the court can make or break your unlawful detainer case. And then the last thing is that there really are no legal workarounds, right? You cannot legally offer or force tenants to vacate a unit without there being some sort of formal relocation assistance. So forcing a vacancy in any situation without following all the legal requirements is an extreme legal risk for landlords. So the next type of legal risk I want to talk about has to do with security deposits and all the legal limitations that go into that. So California does have deposit limits, which typically are about 1 month's rent. There are some exceptions to this, but again, I would advise you, unless you have consulted with an attorney or reviewed these laws, to not go past 1 month's rent for your security deposit requirement. Additionally, there are very specific things that you are allowed to or not allowed to deduct for after a tenant has moved out. So unpaid rent you can deduct for, damage that goes beyond wear and tear, which sometimes is difficult to define. Consult with your property management expert to double check that. And of course, cleaning if required. Not just cleaning as a base rule, but cleaning when it is definitively required is something that you can deduct for. Now, critical, very critical, I wish I could have that in red for you, is the 21-day timeline that is required to return the security deposit with an itemized letter, statements listing out exactly what we charge for, and now there is a requirement to also include photo documentation of the before state and the after for these itemized deductions and any work that was done. All of this has to be provided within that 21-day timeline. And of course, the last thing that I want to mention is that documentation is going to drive your outcomes. So making sure that you are extremely thorough with your documentation before a tenant even moves in is going to save you tons of headaches down the road when you're having to do a security deposit deduction later on. So the next type of legal risk to be aware of is fair housing. Fair housing laws don't only have to do with federal protections, but there are expanded cases, or not cases, classes in California. What do I mean by that? We all understand that you can't discriminate based on race, based on gender, but in California, you have to make sure that you are being very careful not to discriminate based on source of income, right? So Section 8 is something that you'll often hear DIY landlords saying, "Oh, I don't accept that." Ouch, that's a fair housing violation right there. And it's important to note that fair housing violations can happen in your marketing, it can happen in your tenant screening process, and it can even happen in your communication, right? So most of these violations that happen are unintentional, right? I just spoke with an owner who wanted to do a viewing themselves at a property and talked to the tenant that went to go view it, and I had to give so many recommendations to make sure that you are not unintentionally giving them the opportunity to feel that you have violated fair housing in some way. So things as simple as asking, "Oh, you have kids, how many do you have? Oh, you and your partner aren't married, how long have you been together?" As much of those conversations foundational, wonderful questions are to get to know someone when it comes to screening a tenant, that can be a major fair housing violation should you ever decide to restrict this person and not approve them to move into your property. You could be facing a potential fair housing violation. So make sure that you are being very consistent in your processes to limit your exposure. All right, the next legal risk I want to talk about, if I haven't scared you away from turning off this video yet, has to do with rent control and lease regulation. So Assembly Bill 1482 that I just talked about a moment ago does cap the amount that you can increase rent. Now, I will say this has to do with properties that fall under AB 1482, so check if your property might be an exception, but that does limit the amount that you can increase your tenant's rent within a 12-month period to 5% plus CPI, and that maxes out at 10%. So when we had those COVID inflations that were over 11% over the last few months, it still maxed out that rent cap at a total of 10% increase over 12 months. So make sure you're aware of what CPI is and you don't go above 5% plus CPI. The next thing I want to talk about are the tenant protection guides that specifically impact San Diego County. So there are 3 cities within San Diego County. We have the city of San Diego, the city of Chula Vista, and the city of Imperial Beach that have their own citywide tenant protection guides. And these are important not only so you don't violate those tenant protection guides, but you are legally required as a landlord to provide that to your tenant before the tenancy has ever started. So for us here at Uplift, we provide that in our lease agreement with the tenants initialing at the end of that protection guide stating, "I've seen this, I received it." We also have an additional addenda that we include saying, "You're a City of San Diego tenant. You have a tenant protection guide. Look at the PDF down below." So make sure that if your rental property falls into one of those cities, that you are not only familiar with that tenant protection guide, but that you are also providing it to any tenants you have at rental properties in those cities. So the last thing that I want to say, again, I've talked about a couple exceptions that might apply. Typically, this has to do with single family homes. They usually fall outside of these exceptions. Of course, I'm not going to give you any legal advice, consult with an attorney, but your property might be exempt from some of these rent control increases or from actually providing the tenant protection guide. But when in doubt, I would always provide the tenant protection guide, even if you need to throw in there, FYI, you are exempt from the City of San Diego tenant protection guide, but here's a copy for your reference anyways. So of course, like we talked about, those are the 4 main legal categories where landlords tend to get burned, right? Making sure that you are not serving your notices incorrectly, that you are following, of course, any statutory timelines, primarily that security deposit 21-day timeline. Please make sure that you are thorough in your documentation, that you are filing it all, ideally keeping digital copies, not just paper copies of your documentation. And then make sure that you understand your exemptions for your specific rental property. Not your buddies, not your moms, not your cousins, but your rental property that you have. You need to understand how it falls under all of the exemptions and how you can follow all of the California law that you need to in order to abide by the tenant protection guides. All right, and that's it for today, what we want to cover in terms of the legal risks. If you have any more questions, we'd be more than happy to jump on a call, but I do recommend, of course, always consulting with a legal professional when it comes to your property and the legal risks.